Good morning and welcome to another edition of Legal Access. I'm Dave Priest. Today we're going to be talking about criminal law. We have different topics every week, and we are at a new time here, obviously at 11:30, and thanks for joining us here. On the show we normally have me and three panel members. Today we've got one, so it's going to be one-on-one with me and Kirk Truslow, a defense attorney. Now Kirk, in addition to criminal law, is there anything else that you practice at your firm?
No, just criminal defense law.
Okay.
Yeah.
All right, so if you have any questions here today, the phone number's on your screen. Give us a call at 843-848-8080. Anything on the criminal law side, DUI, drug arrest, anything about the court system, the legal system in general, plea bargains, etc. We'll be happy to answer those questions. Again, phone number's on the screen. Don't be shy. Give us a call sometime over the next 30 minutes, but don't wait till the very end of the show. Now, Kirk, I watch a lot of the crime shows, and if you've watched this show before, you know that. I've mentioned it several times, but a lot of times if somebody has been arrested for a criminal offense, or if they're just brought in for questioning and they're being asked to take a polygraph, they're usually pressured into doing that by saying, okay, you need to do this to show that you're innocent. Now, what's your suggestion? Is it kind of like a breathalyzer that, I mean, you don't want to give the prosecution any additional evidence against you?
Yeah, I think the best thing to do is to request an attorney. Everybody who gets arrested has a right to an attorney, a right to remain silent. Surprisingly, not everybody uses those rights, and it is it can be overbearing sometimes when you have 3 or 4 or 5 police officers, detectives, to asking you to prove your innocence, basically, and telling you we want to get you out of here. We just need to clear you. They can kind of talk you into doing something like that, but you have a right to an attorney immediately.
Right.
And once you ask for that, then no more questioning can happen. They have to stop all questioning.
Right. Yeah, but whenever you see these shows, once somebody says, I want to have a lawyer, they automatically say, well, this guy's guilty because he just lawyered up.
Oh, yeah.
So, I mean, obviously that's not the fact.
Yeah, no, definitely they play that card.
Yeah.
Yeah. And a lot of people think that. Why wouldn't you talk to the police if you didn't do anything? But what happens is a lot of times you can say things you're mistaken about later, or that you didn't mean, or it's taken out of context. With something that serious, particularly when there's serious allegations lodged against you, you don't want to say anything that might be taken wrong or the wrong way, because all of that would be used against you later.
Right. Now, I mentioned breathalyzers a couple of minutes ago. Let's go ahead and go to DUI here for a second. If somebody is arrested under suspicion of DUI, do you suggest that they take a breathalyzer test? Did they blow or not blow?
Well, that's a tough one now. The general answer is not to blow, because you're providing evidence on a scientific basis of what your blood alcohol content is. However, now they've made it problematic if you do refuse to take the test, because now many of the collateral consequences that go along with being convicted of a DUI, you suffer if you refuse to take a test, or if you take the test and blow too high. So really, if you had 1 beer or 2 beers, maybe you take the test. It's just a judgment call. But if you shouldn't, you shouldn't. If you pass that line, there's no reason to give them any more information. However, if you do refuse, or if you blow a .15 or higher, you're going to have the same conditions as if you were convicted of the DUI itself. You're going to have SR-22 insurance. You're going to have the ignition interlock in order to drive, which is the blow machine.
Why don't they, in the state of South Carolina, have the roadside breathalyzer? Why do they make you come back to the police station to do that?
I'm not sure. I don't know. I guess it's just preference, or maybe they think it's a better system. Not sure.
Now, whenever we talk to, usually we have somebody here, we might grow as far as our panel is today. We'll see if anybody else shows up. But as far as the solicitor's office, whenever we do a criminal law show, we usually ask about the number of people that move through the system. And it's thousands of arrests that happen each and every year in the 15th Circuit, which is Horry and Georgetown County. So they obviously don't have enough time to go to court for all of those cases. So they are looking for plea bargains on most of those cases. Do you, as a defense attorney, do you use that to your advantage to think, okay, well, they don't have time to try all of these, so if we give them this deal, it's better that they'll probably take that deal?
Yeah, definitely. there is no possible way that you could get all the cases that are brought into a courtroom for a trial. It's just theoretically and practically impossible. So you do have to plea bargain. So what you're going to do is generally a lawyer is going to build the case the strongest that he can in order to see if the prosecutor wants to pick this one to go forward or not, knowing that they can't do all of them. So they're going to look for the more serious ones. They're going to look for the ones where they can force a plea to the actual DUI or convict them at trial.
Right.
So you want to position yourself to be able to take advantage of that anytime.
There are a lot of diversion programs that are out there as far as I know in Horry County we've got the DUI court and drug court so that you might be able to go through without going through the court system to go through these diversion programs where you go through all the program. I mean, whether it's youthful offender or some of the diversion programs, you think that those are good to have?
Yeah, they definitely are, because one, it helps the state because, as I said, they cannot process and try all the cases that they have, so they have to dispose of them some way or another. And it helps the defendant or the person charged because it gives them a route to take to avoid being convicted of the offense. And it doesn't mean they're going to come out scot-free. For instance, the treatment court is really no joke anymore. I mean, it's a lot of meetings, it's drug testing, and if you flunk out of it, you just go to jail.
Right.
There's no hearing to determine what happens to you if you get kicked out of that program. You just go do the time that was assigned to you if you did flunk out of it. So it's not a cakewalk.
Right. Now I know you have like youthful offender diversion programs. What about somebody like me who's obviously not youthful anymore? What if I do something just stupid on a whim and I get caught for doing it and I get convicted and they're like, okay, even though this is your first offense, we're going to send you out to jail, or do I have any recourse?
Yeah, there are, provided you put the case together strong enough and they want to proceed on it, not dismiss it. Even though you're not young, you still have some diversion program available to you. One is pretrial diversion.
Yeah.
One is the treatment court we talked about. The pretrial diversion program is not qualified by any age whatsoever. You have to have a clean record, and the hope is to keep it that way. And if you do everything you're supposed to do during that period of time you're in the intervention program, then the case is dismissed and the arrest record is expunged.
Right. Well, I have no convictions, at least to this point in time. Convictions.
So you'd qualify.
So I probably qualify for something. Tell you what, we're going to take a quick little break here right now. When we get back, we would love to talk to you if you have any questions about criminal law. We're here for you today. The phone number's on your screen, 843-848-8080. Call us today if you have any questions about DUI, drugs, court system, legal system in general, plea bargains, bonds, whatever you have questions about. Call us here today. We'll get you on here. It's Legal Access, brought to you by the McGuire Law Firm. Welcome back. It's Legal Access, brought to you by the McGuire Law Firm. We're here for you each and every Thursday rather, at 11:30. We got our brand new time that we started a couple of weeks back. So if you're not used to it yet, we are here at 11:30, and we'd love to hear from you. If you have any questions today, our topic is criminal law. So if you have any questions about DUIs, drug convictions, or drug arrests, arrest in general, the court system, the legal system, bonds, plea bargains, whatever it is, we'll be happy to answer those for you today. Kirk Truslow is joining me here today, and our phone number's on your screen. On the phone for us right now, Thomas in Conway. Thomas, hi, thanks for calling in and thanks for hanging on through the break. What's your question today?
My question is this right here. I had a YOA in 1987. Is that, after I'd done the YOA, now it's 2025, is that expunged?
That should be expunged. If it's not, it definitely qualifies to be expunged. If you have a youthful offender sentence, then 5 years after the end of the sentence, then it can be expunged, the arrest record, all of it. So you might want to check to see if it's expunged, because if it's not, it qualifies to be expunged. And the state will actually help you do that. You don't have to hire an attorney to get it expunged under a Youthful Offender Act. They have people in their office that handle expungements.
All right, well, Thomas, hopefully that helps you out. And who should he contact?
Well, He could look at the Horry County Public Index, just first of all, to see and run his name and see if he's on there for that matter, and see
Right.
if it's come off yet. If it has not, he would contact the Horry County Solicitor's Office.
All right. All right, well, Thomas, you've got some homework. Go ahead and do that, and thanks for calling in here today. Our phone number's on your screen if you have any questions about criminal law here today. Barbara from Myrtle Beach is on with us. Barbara, hi, thanks for calling in. What's your question?
My question is if you could explain what the different degrees of felonies are, like first, second, or third, and which is like how is that how do they determine what those felonies are?
The crimes are classified as certain classes of felonies and certain classes of misdemeanors. So with the felonies, just say you have Class A, Class B, Class C, Class D, and Class E. They fit into, Class A would be the most serious. So they fit in under how much time they carry, how serious they are, what the potential sentence is. And how they determine what that sentence is up to the legislature. And you know, they determine which is the more serious cases and then assign a penalty. For instance, a Class A felony obviously would be murder, which is 30 years to life. Failure to, no, that's not a felony. I'm trying to think of a small felony. Assault and battery, second degree, carries more than a year. That could be. But that's how they put it together. That's how the lawmakers put it together.
Well, I think, and if I'm wrong, Barbara, sorry about this, but I think she's wondering, and it makes me think, how does the solicitor know, okay, well, it goes over the line from a Class B to a Class A. I mean,
Right.
What's that dividing line between the different classes?
It's enumerated. I mean, it's written down in the law.
Okay.
So there'd be a statute you could find that lays out Class A felonies, and it would put every offense that we have in this state that's a Class A felony would be listed underneath that. And then you would have a Class B felony, the same thing, and on and so forth. And the misdemeanors are also classified.
All right, Barbara, hopefully that helps. Thanks for calling in here today. If you have any questions about the legal system in general, courts, plea bargains, any of that stuff, DUI, drug arrest, give us a call here today. 848-8080 is our phone number. And as far as a court itself is concerned, as a criminal defense attorney, you hear a lot of people always undermine some defense attorneys if they put their client up on the stand to testify in their own defense. Is that a mistake or not?
It can be a mistake. What happens when you put your client on the stand, when the defendant takes the stand, at that point in time, he has voluntarily placed his character into the trial. And at that point, anything he's done in the past, if it qualifies, like prior criminal conduct, is admissible. If he does not take the stand, the judge tells the jury that they can't even consider that in their deliberations
Right.
at the end of a trial, and he's got the right not to testify, and they cannot bring in anything that 2 years ago he committed a bank robbery.
Right.
Whereas if he takes the stand, they're going to beat him over the head with any prior record that he has, and it's going to make him look bad. It's pretty prejudicial.
Why, I guess a lot of people would wonder, why can't you bring in like prior offenses? I mean, if somebody, because I always talk about, hey, they want to bring in somebody as a character witness, but if somebody has a witness against somebody's character,
Yeah.
you can't do that.
That's just one of the tenets that comes back from the common law, that the person's character is not, we have evidentiary rules. So the theory is that you're supposed to be convicted for the conduct that you committed,
Right.
not for anything that you've done in the past or what kind of person you are. So it's to focus on the facts and evidence that are present in that particular case,
Right.
and nothing else.
Now, as far as court itself is concerned, jury selection, I know in the state of South Carolina we have a different jury selection process than some other states. It's very much streamlined. So you don't get a chance to question the jurors, potential jurors, individually to see whether or not they want to fit what you're looking for.
Right. In some states, you actually spend time, when you pick a jury, interviewing the jurors. And you get to ask them questions, you get to follow up on questions with them, you sit back and forth with the jury, and the prosecutor does as well, and you learn a lot about the juror, potential juror, if you want him on your trial or not. In our state, we do not have that. We have the judge will ask questions to the jury, and usually there are summary questions, whether they know anything about the case, if they heard anything about the case, questions like that. Now, we do have the right to submit written questions
Right.
to the judge for him to ask, and he can decide whether or not he's going to ask them.
Right. Okay. Criminal law is our topic. If you have any questions about it, please feel free to give us a call. The phone number is on your screen. If you have any questions about drug arrest, DUI arrest, the court system in general, or plea bargains, bonds, any of that kind of stuff, give us a call. That's fair game. We've got about 10 minutes left in the show, so don't wait to the very last minute, because this is the very last minute. Call us up at 848-8080, and we'll get you on the air here in just a second. It's Legal Access, brought to you by the McGuire Law Firm. It's Legal Access, brought to you by the McGuire Law Firm. Criminal law is our topic here today. I'm Dave Priest, along with criminal defense attorney Kirk Truslow. It's one-on-one here today, so we appreciate you watching us at our brand new time at 11:30 until 12. We talked about bonds a little bit earlier. Now, the prosecution and the judge, when they set a bond for somebody, what goes into the decision on how much that bond is going to be?
There are two elements only that are supposed to be considered. And they're not really supposed to consider what the offense is or how bad it is. It's supposed to be, one is a risk of flight. What type of risk does that person pose? They have a passport, they have plenty of money, they have a second home somewhere overseas. The second is danger to the community. Now, in that respect, you can kind of look at what the offense is. If it's a murder case, you could argue there's a danger to the community. But those are the two elements that are looked at in a bond.
Now, Thomas earlier today when he called, he talked about expunging records. Now, we get a lot of calls during whenever we do criminal law as our topic as far as expunging records. What is available to be expunged, and what kind of process do they have to go through if they want to get it off their record?
Well, first, if you are charged with an offense and it's dismissed, or you're found not guilty, obviously the arrest record for that's going to be expunged, and that is actually done by the state. You don't have to take any steps to do that. If you are fortunate enough to get in one of the intervention programs, a treatment court, or the pretrial intervention program, or anything else like that, youthful offender, those offenses can be expunged. And then we have a statute that lays out other offenses that can be expunged. And they actually expanded that and added possession with intent to distribute some certain drugs, but after 20 years. But still, at least it's in there. 20 years can go by, and if you have an old record, you could have that expunged.
Do you have to go through the Attorney General's office, or?
Through the Horry County Solicitor's office. They handle that. But if it's something that you have to do, then you just file a form, an expungement form with them, and they take it from there.
Now, as I said earlier, I do watch a lot of the TV shows that have to deal with crime, and a lot of times you'll see the cops out on the street, and they'll say, okay, we need to go to the district attorney or solicitor in our case, because I don't think we have enough evidence against so-and-so to get a conviction. And so they continue to try to rack up more evidence against whoever. Does that happen in real life? I mean, around here or anywhere else?
Yeah, that happens in real life. The solicitor's office generally has a prosecutor who's on call, and that person is responsible for responding to police officers in those situations. And if they have an evidence question, or they have a question about whether they could charge the person with a certain offense, if they have enough evidence, which offense might be more appropriate. And those prosecutors who are on call have actually gone to the crime scenes before, and so there is that interaction between the police and the prosecutors.
Now, when somebody gets arrested or brought in, I mean, if it's not just a clear-cut arrest, and they give you a call and they say, Mr. Truslow, I'm behind bars right now. I mean, how do some of those calls go that they're looking for help? I mean, and what can you do for them when they're actually been locked up?
Well, the first thing you can do is, and what becomes the first priority is getting the person out of jail. So scheduling a bond hearing. And there are certain offenses where the bond hearing may not happen for a little while, and you can speed that process up. If it has to be heard in the circuit court, for instance, and there's no court that week, or it's full or whatever, you could be sitting for a little while, despite your right to a bond. If it's not like that, and the magistrate court's going to set the bond at the jail, you're usually going to skip one or two bond hearings because they're processing, they got a lot going on, so you might be there a day, but you can try to get it as quick as possible. and have representation at the bond
Right.
hearing. That shows you're serious about the case. You're less of a risk of flight because you engaged an attorney,
Right.
and then you can bond out. That's generally the first thing that happens.
Now, the Constitution guarantees us a speedy trial. I mean, what constitutes a speedy trial? Because we talked earlier in the show about a number of cases we have in just Horry and Georgetown counties, and just the number of weeks, which is very small to be able to trial those cases. So you might, from the time you get arrested or charged until the time you actually have an event in court, might be 2.5, 3 years or longer.
It can be, yeah, it can be years. The federal system has a speedy trial law, and it's in statute. Congress passed it. So when you get indicted, that clock starts running for real. Now, there's certain exceptions where it takes out time and pauses, if the defendant causes some pause.
Right.
In the state court, there have been cases that said 5, 6 years is not a violation of a speedy trial.
Right.
So whether we have that or not is a case-by-case basis. And what they look at in the state court is really whether you've been, not so much how long you've waited, but whether you've been prejudiced by that or
Right.
not. Like there's witnesses you wanted to call that are now dead, and you would have called them and used them, they would have helped you, things like that.
As a criminal defense attorney, we see a lot of times where somebody will say, okay, they've gone into the deliberation room, to the jury room to take votes, and they've come back out with an hour and a half. What does a quick verdict mean? I mean, a lot of people say, we know that means it's going to be the prosecutor's case, or vice versa.
Generally, I've found in my practice that when I've tried cases that the quick verdicts, when they come back, are not guilty. They go back and they have a consensus about that right away. Generally, if they're going to convict somebody, they're going to take a little more time because they're sensitive to that and what that means to the person to convict them. So if nothing else, they want to talk about it and at least have the image of having gone through the evidence and discussed it beforehand.
When you're presenting a case to a jury, can you look at their eyes and tell whether or not that they're buying what you're selling, if I put it that way?
Sometimes you can, but sometimes you can get fooled too. I mean, I've been fooled before and had somebody that I thought was with me the whole way nodding their head, and obviously what they were thinking was, yeah, he's guilty, and not for me. But yeah, you can get an idea. Some people will shake their head or use body language, but certain points you make, that helps.
All right, thanks for watching here today. Again, at our new time, 11:30 until 12 each and every Thursday. Legal Access is coming your way, brought to you by the McGuire Law Firm. Next week when we get together, we're going to be talking about workers' compensation. So if you've been hurt on the job, or you have a family member or a loved one who has, we'll be able to answer those questions for you next week. If you have any questions in advance, you can email us. Our email address is legalaccess@wmbfnews.com. And if you have any further questions about criminal law that we didn't answer today, or you didn't get a chance to call us, you can go ahead and use that same email address, legalaccess@wmbfnews.com. We'll answer the questions for you off the air and get back to you that way. So again, I want to thank our panel here today, made up of one man who was able to handle all these questions today, Kirk Truslow. So we appreciate that, Kirk. Thanks for being here for us today.
Thank you, Dave.
And next week, like I said, workers' compensation will be our topic. So again, if you have any questions about workers' comp, if you've been hurt on the job or know somebody who has, that's next week's show, 11:30 until 12 right here on WMBF News. See you then.
You may wish to consult a lawyer to obtain case-specific legal advice. Information regarding lawyers can be located online or by contacting the South Carolina Bar Lawyer Referral Service, toll-free at 1-800-868-2284. If you are currently represented by an attorney, you should direct all legal questions to your attorney. The nature of any legal issue may depend on a multitude of factors. Therefore, the information provided in this program is purposefully broad and does not constitute legal advice.